However, there is a section on here for those who are non-compliant. And one of the reasons for non-compliance may be that they've had more than one high BAC. It's also important to note that the compliance requirement is more than one high BAC over a 0.08. So, and the car doesn't start at 0.05. So they've failed 20 tests in that last 30 days, but none of them registered as 0.08. They're still in compliance. However, if they're not, we will check a box that says non-compliance. The non-compliance, once we check a box that's non-compliance, we send that to the client, and then we also send a copy to motor vehicles and the sentencing court, which is required by statute. At which point it's on the client to get back in front of the judge. So when we were creating this compliance portion back in 2019 of the legislation, at first they wanted the compliance to be on us as the interlock providers. And somebody realized that that might not be a great idea because it might not necessarily be in our interest to take out a lot of interlock devices. So maybe don't give it to them. And then the next available resource they thought was motor vehicles. And they said, well, we'll have motor vehicles monitor it. And motor vehicles said, no, we don't have the manpower. We're still waiting on our new computer system. And they were unable to handle it. And one of the aides or legislators or whoever was involved in the process on that end, maybe somebody from OLS, said that, you know, it's a judge's sentence. So it should be up to the judge whether or not, you know, to determine compliance. So they sent it back to the judge, but they never really made a mechanism for the client to get back in front of the judge. So we do have clients who are in compliance, who are, you know, who fight a little bit to get it back in front of the judge in some cases. But most of it, you know, in a lot of cases, they will seek representation, at which point that might help speed the process along. And the judge can look over the record. They can have any information they need from us, obviously. We would provide it. But the judge can look over whatever it is they want to look over, and they can, by statute, make a determination of one or two things. Option one is to extend the sentence for up to 90 days, at which point on the 91st day, they can come in for their final download. We will check the last 30 days of the record, and should they be in compliance, we can give them a compliance certificate that they can then take to motor vehicles to have the restriction removed. The other option for the judge would be to order the removal of the IID, at which point we would like for the client to call us and let us know and make that a removal appointment, telling us that they have an order from the court to remove the device. They will bring that order with them, and with that order, we will check off the portion of the interlock of the certification. There's compliance, non-compliance, and then there's compliant by judge's order, and that's the box that we check in that situation, at which point the process continues on as if they were in compliance. They then take that piece of paper down to motor vehicles, get the restriction removed from their driver's license, return to the service center with a clean driver's license that we can take a picture of to prove that they no longer need the ignition interlock device, and at which point we will then remove the device and send the client on their way, no longer interlock restricted either on their license or in their vehicle. As I had said before, I'd like to be a resource to anybody who has any questions. If there's something that I didn't go over that you might be interested in, or if you ever wanted to run any sort of scenario by me in regard to a client situation, I can be reached at either of those numbers there. And my email address is jason@idnj.com, just as it is on your screen in front of me. And that concludes my presentation for today. Are there any questions? Are there any questions in the queue?